When people think about divorce, they often focus on alimony or child support. But in many Connecticut divorces, real estate is the most important financial aspect of the case. And it's also one of the most misunderstood. Whose name is on the deed, who paid for the house, whether the property was owned before the marriage, none of those things work the way most people think they do. So in this video, I'm going to explain how real estate is divided in a Connecticut divorce case, what judges actually look at, and what options people realistically have when it comes to the marital home and other properties. To understand how real estate is divided, you first need to understand Connecticut's legal framework. Connecticut is an equitable distribution state, which means the court's goal is fairness, not an automatic 50-50 split. And here's a critical point that surprises a lot of people. In Connecticut, the court can divide all property regardless of whose name it's in, when it was acquired, or whether it was owned before the marriage. So even property owned by one spouse before the marriage can be considered by the court when dividing assets. However, courts do often allow parties to retain any premarital equity they had in real estate. So with that framework in mind, let's talk about what types of real estate are actually in play. In a Connecticut divorce, real estate can include the marital residence, vacation or second homes, rental or investment properties, commercial real estate, and undeveloped land. If it's real property and one or both spouses have an interest in it, the court can consider it as a part of the overall division. Now, the fact that all real estate can be considered doesn't mean it's divided the same way in every case, because the analysis is highly fact-specific. When deciding how to divide real estate, Connecticut judges apply statutory factors that focus on fairness. Some of the most important considerations include the length of the marriage, each spouse's contributions, both financially and non-financially, each party's earning capacity, the causes for the breakdown in the marriage, the needs of any minor children, and each spouse's opportunity to acquire other assets in the future. Judges don't apply these factors mechanically. They look at the entire financial picture and decide what result makes sense for that particular family. Now, this brings us to the property that usually generates the most conflict, and that's the marital home. The marital residence is often where emotion and law collide. Judges look beyond sentimental attachment and focus on practical realities such as whether one spouse can realistically afford to keep the home, the cost of the mortgage, taxes, insurance, and maintenance, whether keeping the home provides stability for children, whether retaining the home would unfairly burden one party. It's very common for people to fight hard to keep the house, only to later realize they can't afford it on a single income. That's why courts tend to focus on feasibility, not just emotion. Once those considerations are weighed, there are a few common outcomes. First, sale of the property. The home is sold, the mortgage and costs are paid, and the net proceeds are divided. This is often the cleanest and least risky option. Second, one spouse may buy out the other. This usually requires an appraisal, a refinancing of the home, and the financial ability to carry the property alone. If refinancing isn't possible, this option may not be realistic. Third, a deferred sale. Sometimes the sale is postponed, often until children reach a certain age. While this can provide short-term stability, it keeps the parties financially tied together and can create future disputes. And fourth, an unequal distribution. One spouse may keep the real estate in exchange for giving up other assets such as retirement accounts or cash. Each of these outcomes depends heavily on valuation, which is often its own battle. In real estate division, what matters is equity, not purchase price. Equity is the value of the property minus the mortgage, any home equity loans, and other liens or encumbrances. Valuation is typically determined through a formal appraisal, or in some cases, the parties may do a market analysis. But disputes often arise over the accuracy of the appraisals, timing of the valuation, or changes in the real estate market. And valuation directly affects whether buyouts and sales are even possible. There are several mistakes I see people make repeatedly, assuming the house automatically stays with the spouse whose name is on the deed, or ignoring the true cost of owning the home post-divorce, failing to address refinancing timelines, overlooking tax implications, or using the house as leverage without understanding the consequences. Real estate decisions made during divorce can affect people for years, and sometimes decades. One final point worth mentioning is the difference between settling and letting a judge decide. Judges have broad discretion, but negotiated agreements allow for more creative solutions, greater predictability, and more control over the outcome. Many real estate disputes are resolved through settlement because the parties can structure outcomes a court simply wouldn't impose. So those are the basics on how real estate is addressed in Connecticut divorce court. As usual, if you have any additional questions, you can contact our office, and if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.